Good day, ma'am. My name is Analou Cardinas from BSHM 3A. I'm going to report Comprehensive Legal Services, Chapter 13. A motivated worker will be a productive worker. Learning objectives enumerate the classification of employees, their benefits, privileges, and policies affecting them. Identify some best practices in handling human resources in tourism establishments. Identify the procedures in handling sexual harassment in the workplace. And lastly, explain the rights of workers employed in tourism. Topic outlines: Introduction, Constitutional provisions on labor, employees for a fixed term, overseas Filipino workers, special workers, benefits, privileges, policies affecting employees, collective bargaining, labor management, maternity and paternity leaves in the Philippines, union rights, strikes and lockouts, service charges, employment contracts, death benefits, health benefits, drug testing, retirement, uniform policies, SSS, field health policies, employees compensations and pag-ibig, laws against discrimination, employment of women, sexual harassment in the workplace, best labor practices in tourism establishments, and conclusion. The tourism industry, with its labor-intensive nature, is prone to many labor issues. Hence, labor law plays a vital role in the efficient operation of the various business enterprises related to tourism. This chapter deals with important provisions governing labor laws as well as the benefits, privileges, and policies affecting employees. Constitutional provisions on labor. The law. Section 3. The state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. This law explains that the government must protect all workers, whether they work in country or abroad, and whether they belong to a labor union or not. It also says that the government should help create jobs for everyone and ensure that all people have equal chances to get employed without discrimination. It shall guarantee the rights of all workers to self-organization, collective bargaining, and negotiations and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security to ensure human conditions of work and living wage. They shall also participate in policy and decision-making process affecting the rights and benefits as may be provided by the law. The state shall promote the principle of shared responsibility between workers and employers and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. The state shall regulate the relations between workers and employers, recognizing the right of laborers to its just share in the fruits and of production and its rights of enterprises to reasonable returns of investment and to expansions and growth. The law ensures that all workers have the right to form groups, negotiate with employers, and join peaceful protests, including strikes, as long as they follow the law. Workers must also have job security, fair working conditions, and wages that allow them to live decently. They should have a say in decisions that affect their rights and benefits. The government encourages workers and employers to work together and resolve conflict peacefully through discussions and agreements. It also makes sure both sides follow these agreements to maintain harmony in workplaces. The government oversees the relationship between workers and employers, ensuring that workers get a fair share of company profits while businesses earn enough to grow and succeed. Section 14. The state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions and such facilities and opportunities that will be enhance their welfare and enable them to realize their full potentials in the service of the nation. The law ensures that women have safe and healthy working conditions considering their roles as mothers. It also provides support and opportunities to help them grow and contribute to the country. Section 15. The state shall respect the rule of independent people's organizations to enable the people to pursue and protect, within the democratic framework, their legitimate and collective interests and inspiring aspirations through peaceful and lawful means. The government values independent organizations that help people protect their rights and interests in peaceful and legal way. Section 16. The right of people and their organizations to effectively and reasonably participate at all levels of social, political, and economic decision-making shall not be abridged. The state shall, by law, facilitate the establishment of adequate consultation mechanics. This explains that people and organizations have right to take part in the important decision about society, politics, and the economy. The government must create ways to involve them in these discussions. Casual employees. Casual employees are those whose employment is neither regular, project, nor seasonal as defined under Article 280 of the Labor Code. There is casual employment where an employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer, and such job, work, or service is for a definite period made known to the employee at the time of engagement, provided that any employee who has rendered at least 1 year of service, whether such a service continues or not, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. The next is seasonal employees. Seasonal employees are those whose work or services is seasonal in nature and the employment is for duration of the season. Regular seasonal employees are those called to work from time to time. The nature of their relationship with the employer is such that during off-season, they are temporarily laid off, but during summer season, they are re-employed or when their services may be needed. They are not strictly speaking separated from the service, but are merely considered as on leave of absence without pay until they are re-employed. Their employment relationship is never severed but only suspended. As such, those employees can be considered as in regular employment of the employer. In effect, these seasonal regular employees enjoy security to tenure and cannot be dismissed without just cause. The next is project employees. A project employee is one whose employment has been fixed for a specific project or undertaking, the completion of termination of which has been determined at the time of the engagement of the employee, or where the work is services to be performed in seasonal in nature and the employment is for the duration of the season. The principal test for determining whether an employee is a project employee or a regular employee is whether the project employee was assigned to carry out a specific project or undertaking, the duration of scope of which were specified at the time the employee was engaged for the project. Failure of the employer to file termination reports at every project completion with the nearest public employment office an indication that an employee is not a project employee. It explained that a project employee is someone hired for a specific project or task with a clear end date or based on seasonal work. The main way to know if an employee is a project worker or a regular worker is to check if they were hired for a specific project with a set duration from the start. If an employer does not report the employee's termination after the project's completion to the public employment office, it may suggest that the worker is not actually a project employee but a regular one. The next is probationary employees. A probationary employee is one who is on trial by an employer during which the employer determines whether or not he is qualified for permanent employment. Probationary employment shall not exceed 6 months from the date the employee started working. In all cases of probationary employment, the employer shall make known to employee the standards under which he will qualify as a regular employee at the time of his engagement. Where no standards are made known to the employee at the time, he shall deemed a regular employee. It explained that a probationary employee is someone who is a trial period so the employer can decide if they are fit for a permanent job. This trial period cannot be longer than 6 months. The employer must clearly tell the employee what requirements they need to meet to become a regular worker. If the employer does not set any standards at the start, the employee will automatically be considered a regular worker. Probationary employment shall be governed by the following rules. A. Where the work for which the employee has been engaged is learnable or apprenticeable in accordance with the standards is prescribed by the Department of Labor and Employment. The period of probationary employment shall be limited to authorized learnership or apprenticeship period which is applicable. B. Where the work is neither learnable or apprenticeable, the period of probationary employment shall not exceed 6 months from the date the employee actually started working. C. The services of any employee who has been engaged on probationary basis may be terminated only for a just authorized cause when he fails to qualify as a regular employee in accordance with reasonable standards prescribed by the employer. It is settled that a probationary employee enjoys only a temporary employment status, not a permanent status. In general terms, he is terminable anytime as long as such termination is made before the expiration of 6 months probationary period. The employment of probationary employee may only be terminated either for a just cause or when the employee fails to qualify as a regular employee in accordance with reasonable standards made him by the employer at starts of the employment. The power of the employer to terminate employees on probation is subject of the following conditions. Number 1, it must be exercised in accordance with the specific requirements of the contract. Number 2, the dissatisfaction on the parts of the employer must be real and in good faith, not prejudicial so as to violate the contract of the law. Number 3, there must be no unlawful discrimination in dismissal. The burden of providing just or valid cause of dismissing an employee rests on the employer. The next is employees for a fixed term. These are employees covered in employment contracts providing for term enjoyment or fixed period employment. Stipulations providing for a fixed period employment are valid when the period agreed upon is knowingly and voluntarily agreed by the parties without force, duress, or improper pressures exerted on the employee, and when such stipulations were not designed to circumvent the laws on security of tenure. The following are the guidelines which must be observed in order for fixed contracts of employment may not circumvent security or tenure. Number 1, a fixed period of employment was knowingly and voluntarily agreed by parties without any force, duress, or improper pressure being brought to employee and absence any other circumstances violating his consent. Or number 2, it satisfactorily appears that the employer and employee dealt with each other on more or less equal terms with no moral dominance whatever being exercised by the former on the latter. Overseas Filipino workers, also referred as a migrant worker. Overseas Filipino workers refers to a person who is engaged or has been engaged on remunerated activity in a state of which he or she is not a legal resident. A person to be engaged in remunerated activity refers to the applicant worker who has been promised or assured employment overseas and acting when such promise or assurance sustains damage or injury. The law which governs overseas employment is Republic Act 8042 or the Migrant Workers and Overseas Filipino Act of 1995. Special workers. Apprentice. An apprentice is a worker who is covered by a written apprenticeship agreement with an individual employer or any of the recognized entities. It is a person undergoing training for an approved apprenticeable occupation during an established period assured by an apprenticeship agreement. An apprenticeship agreement is an employment contract wherein the employer binds himself to train apprentice and the apprentice is turned to accept the term of training. An apprenticeable occupations means by trade form of employment of occupations which requires more than 3 months of practical training on the job supplemented by the related theoretical instructions. The period of apprenticeship shall not exceed 6 months. Learners. Learners are persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeable and which may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. Learners may be employed with no experienced workers are available. The employment of learners is necessary to prevent curtailment of employment opportunities, and the employment does not create unfair competitions in terms of labor cost or impaired or power or lower workers' standards. Handicapped workers are those whose earning capacity is impaired by age of physical or mental deficiency or injury under Section 4A of RA 7277, also known as Magna Carta for disabled persons. Disabled persons are those suffering from restrictions or lack or different abilities as a result of mental, physical, or sensory impairment to perform an activity in a manner or within the range considered normal for a human being. A qualified disabled employee shall be subject to the same terms and conditions of employment and the same compensations, privileges, benefits, fringe benefits, incentives, or allowances as qualified able-bodied person. This explains that handicapped workers are those who have difficulty earning due to age, disability, or injury. According to the law, disabled persons have physical, mental, or sensory impairments that limit their ability to perform tasks a normal way. However, if a disabled person is qualified for a job, they must receive the same pay, benefits, and work conditions as the other qualified workers. It explained that the law assigns the task of setting minimum wages to the Regional Tripartite and Productivity Board. Minimum wages is not just about setting the lowest salary but also improving wages overall. It aims to boost productivity and ensure that workers and their families have a decent standards of living. This law recognizes the importance role of labor in the economy. The next is collective bargaining. Collective bargaining is the process of negotiating agreement between the employers and employees through their labor union regarding wages, working hours, benefits, and workplace conditions. This results in a collective bargaining agreement (CBA), which covers number 1, management rights; 2, union recognition and security; 3, which is benefits; 4, working conditions; 5, personal management practices; 6, grievance and arbitration procedures; 7, contract duration. Employers must negotiate in good faith but are not required to initiate bargaining. Negotiations begin when a union holds majority representation, proof of majority support is provided, a formal bargaining demand is made under the labor code. Failure to negotiate in good faith, avoid bargaining, or violate the CBA can lead to unfair labor practices which may result in strikes or lockouts. The CBA must be ratified by the majority of all workers in the bargaining unit registered with the DOLE and has a validity of 3 years for provision and 5 years of representation. The next is Labor Management Council. Under Article 255 of the Labor Code, employees, unionized or not, can present grievances to their employer any time. The Department of Labor and Employment promotes labor management councils as forums for communications and dispute resolutions in workplaces. Labor Management Council, when built on trust and integrity, can foster industrial peace and may even render unions unnecessary. However, employee representatives must be elected, not appointed by management. The next is maternity and paternity leaves in the Philippines. Maternity leave, RA 8282, a female SSS member regardless of marital status is entitled to 60 days of paid maternity leave, 70 days for C-section if she had paid at least 3 monthly contribution in the 12 months before childbirth or miscarriage. Employers must advance full payment within 30 days, which SSS will reimburse. The benefit applies only to the first 4 deliveries or miscarriages. Paternity leave, RA 8187. A married male employee is entitled to 7 days of fully paid leave for the first 4 deliveries of his legitimate spouse, provided he is living with her and applies for the leave properly. Solo parents leave, RA 8972. A solo parent who has worked for at least 1 year is granted 7 days of parent leave annually. The next is union rights strikes and lockouts. A legitimate labor organization can sue on behalf of its members for individual money claims. To engage in collective bargaining, a union must be certified as exclusive bargaining agent through a certification election. This explains that a legitimate labor organization can file a case to claim money owed to its members. For a union to negotiate with employers, it must first be officially recognized through certification election. A strike is a temporary stoppage of work by employees due to a labor dispute, while a lockout is an employer's temporary refusal to provide work. Labor disputes covers issues related to employment terms, conditions, and representation. So it explained that a strike happens when workers stop working temporarily because of labor dispute, while a lockout is when an employer temporarily stops giving work. Labor disputes includes disagreements about wages, working conditions, and work representation. Valid grounds for strikes and lockouts are collective bargaining deadlock and 2. Unfair labor practices. For a strike to be lawful, it must comply with notice filed with the Department of Labor and Employment to lay via NCMB, cooling off period 30 days for a deadlock, 15 days for ULP with NCMB mediation. Strike vote by secret ballot approved by the majority. Notice of strike result to NCMB at least 7 days before action. No strike lockouts if the Secretary of Labor or the President assumes jurisdiction. Unfair labor practices violate workers' right to self-organization, disrupt industrial peace, and harm labor management relations. The next is service charges. The rule of service charges applies only to establishments collecting service charges such as hotels, restaurants, lodging houses, nightclubs, cocktail lounge, massage clinics, bars, casinos, gambling houses, and similar enterprises, including those entities operating primarily as private subsidiaries of the government. All service charges collected by hotels, restaurants, and similar establishments shall be distributed at a rate of 85% for all covered employees at 15% for management. The share of employees shall be equally distributed among them. The 15% shall be for dispositions by management to answer for losses and breakages, and distributions to managerial employees at the discretion of management in the latter case. So it explained that the rule on service charges applies to businesses like hotels, restaurants, bars, and similar places that collect service fees. The total service charges collected are divided with 85% given to employees and shared equally among them. The remaining 15% goes to management, which can use it for losses, damages, or bonuses for managerial employees. The next is employment contracts. An employment contract is an agreement where an employee commits to work for an employer in exchange for compensation. It is governed by the Labor Code of the Philippines, the Civil Code, and other laws ensuring terms comply with legal, moral, and social standards to promote industrial peace and social justice. Employment contracts are generally consensual and do not require formalities for validity. However, industries like tourism commonly use written contracts to clarify terms and protect both employers and employee interests, especially for probationary projects-based, casual, and fixed-term employees. Well-structured contracts help employees understand their responsibilities and comply with company policies. Typically, it includes company rules and regulations, Code of the Philippines, missions orders, policy manuals, security safety accountings, day-to-day instructions, job descriptions, standards operating procedures, memorandum from superiors. Clear employment terms foster compliance, understanding, and harmonious workplace. The next is death benefits. Under Social Security law, if the said member has paid at least 36-month contributions, their primary beneficiaries receive a monthly pension. If there are no primary beneficiaries, secondary beneficiaries receive a lump sum equal to 36 times the monthly pension. If contributions are less than 36 months, beneficiaries receive a lump sum based on total contributions or 12 times the monthly pension. whichever is higher, 12,000 funeral grants is provided. Under the Employees Compensation Fund, beneficiaries receive additional monthly benefits plus 10% per independent child to up to 5. The funeral benefits under this fund is 10,000. The next is health benefits. This includes sickness, medical, and hospitalization benefits. Under the Social Security Law, a member who has paid at least 3 monthly contributions in 12 months period immediately preceding the semester of sickness or injury and is confined more than 3 days in hospital or elsewhere with the approval of the SSS shall be paid a daily sickness benefit equivalent to 90% of his average daily salary credit. In case of work-related sickness, the covered employee will be entitled to medical services, appliances, and supplies in addition to the benefits under the SSS law. So the next is drug testing. Under Republic Act No. 9165, drug testing must be conducted by DOH accredited laboratories to ensure quality results. Certificates are valid for 1 year. Employers must implement random drug testing to maintain workplace safety. Employees who test positive may face suspension or termination under Article 282 for Labor Code. Next is retirement. Under Article 287 of the Labor Code, as amended by RA 7641, the new retirement law, an employee may retire at an age is set in a collective bargaining agreement or a contract. If no such plan exists, an employee aged 60 to 65 with at least 5 years or service is entitled to a retirement pay at least 1/2 month salary per year of service, with at least 6 months counted as full year. Next is uniform policies. Some tourism establishments, which include but not limited to restaurants, department stores, rest areas and gasoline stations, deluxe and first-class hotels, tourist inns, special interest resorts, hotels, motels, and those engaged in water transport services, require their employees and staff to be well-groomed and should wear clean and smart uniforms. Uniform policies in these establishments are prerequisite requirements in order to be accredited by the Department of Tourism. The next is SSS PhilHealth Employees Compensation Commissions and Pag-ibig. Private sector employees are covered under the SS law, which provides financial protections against disability, sickness, maternity, old age, death, and other contingencies. PhilHealth manages health insurance for private employees, covering inpatients and outpatients care, including hospitalizations, professional services, diagnostics, and prescription drugs. The Employees Compensation Commissions ECC provides compensations for work-related disabilities through the State Insurance Fund. Under RA 7742, Pag-ibig Fund's membership is mandatory for SSS covered employees, including expatriates, benefits including housing, calamity loans, as well as provident saving programs. The next is laws against discrimination. The law, R3, Declaration of Basic Policy. The state shall afford protection to labor, promote full employment, ensures equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. To explain that the law protects workers by ensuring fair treatment and job opportunities for everyone, no matter their sex, race, or beliefs. It also promotes full employment and regulates the relationship between workers and employers to maintain fairness in the workplace. The next is employment of women. The state ensures that protection of working women by providing safe and healthful conditions while considering their maternal functions. The Labor Code of the Philippines upholds the rights as follows. Women cannot work between midnight at 6 a.m. except for health services for jobs requiring their dexterity. Employers must provide facilities such as seats, separate toiletries, toilets, dressing rooms, and nurseries. It is illegal to require a woman to remain unmarried as a condition of employment or to dismiss her due to marriage. Employers cannot terminate a woman due to her pregnancy, maternity leaves, or the possibility for future pregnancy. Women working in nightclubs, bars, or similar establishments under employer provision are considered employees. The next is sexual harassment in workplace, RA 7877. Republic Act Number 7877, or the Sexual Harassment Act of 1995, defines sexual harassment as any unwelcome sexual demand, request, or favor made by persons in authority, influence, or moral ascendancy in a work environment. It applies regardless of whether the victim submits to or rejects the advances. When a sexual harassment is committed, when sexual favors are made a condition for hiring, continued employment, promotions, or job benefits. When such acts violate employee rights under the labor laws. When they create an intimidating, hostile, or offensive work environment. Employer's duty. Employers must prevent and address sexual harassment by enforcing rules and procedures for investigation sanctions. Examples of workplace sexual harassment: offering sexual advances in exchange for job benefits, unwanted touching, kissing, or suggestive behavior, delaying promotions or benefits in exchange for dates, forcing applicants to expose themselves as a condition for employment, requiring inappropriate uniforms, bikinis for car wash attendants, displaying pornographic materials in workplace, engaging in indecent exposures of sexual acts toward employees. Sexual harassment violates the dignity, equality, and workplace professionalism, requiring strict enforcement of laws and policies. The next is best labor practices in tourism establishment. This topic has been added to enable the readers to appreciate the best labor practices of selected tourism establishments from the lodging industry, travel agency, tour operators, transportation companies, food service industry, tourist sites. It will be noted that 90% of the selected respondents agreed that it is imperative to have a proactive and supportive human resource department, which will be instrumental in enhancing the welfare of the employees and helping the company toward its growth and investment. An open-door policy with the president or general manager of company is most welcome, as it has proven to be the most effective means for removing barriers of communications and enhancing a shared responsibility of nationhood between capital and labor. Employers conduct background checks and two-week orientations for new hires, including immersions, company study, and an exam. Some workplaces replace unions with regular dialogues or labor management council meetings. Performance evaluations occur monthly or quarterly with proactive counseling and written reports. Merit-based pay increases and extensive benefits are provided, along with occasional and spiritual benefit activities. Due process is strictly followed in terminations. Employees receive copies of company policies, job descriptions, and evaluation criteria. Companies prioritize training and development. Some tourism businesses use franchising and contractual employment to reduce labor costs. Government-administered sites follow civil service laws. Law is not an end in itself, nor does it provide justice, but it is the means by which justice is to be served. By Earl Warren. So, in conclusion, Chapter 13 explained the importance of comprehensive legal services in helping individuals and businesses with their legal needs. It shows that lawyers must have knowledge in different areas of law, such as contract, business law, and dispute resolutions, to provide the best support. The chapter also highlights the needs for ethical practices, clear communication, and proper legal advice. By offering complete legal services, lawyers help protect people's rights, solve legal problems, and ensure justice. This makes legal services an important part of a fair and orderly society. That would be all. Thank you.